Delivering this week's must-watch workplace storylines, this is Bloomberg Law's Punching In, for those of you listening in Washington and across the globe.
Hey folks, thanks for punching in with us during election week here. We'll focus this episode on the election's significance to labor and workplace policy. We'll have a bit more in the column on specific contests between different candidates that are vying for seats on the labor panels in Congress. And those folks have a lot of authority in terms of steering labor and workplace policy in the country. So check in with the column for a bit more on that. But first, my colleague Jaclyn Diaz, who covered some state-level referendums, measures, and elections, is here to discuss those. Hey Jaclyn, how are you?
Good. How are you?
Doing well. So you covered some minimum wage measures in Arkansas and Missouri, but what caught my eye was a prison labor measure in Colorado, mostly because of the conversation last week started by the president over what most folks thought was a long-settled question of birthright citizenship. That's relevant to this prison labor thing that you covered because both those policies are enshrined in the 13th and 14th Reconstruction Amendment. So tell us a bit, what exactly does this measure in Colorado do?
So Colorado's question is on changing the state constitution to ban unpaid forced labor by people in prison. If approved, the measure removes the criminal qualifier from the slavery provision.
Yeah, so that sounds like essentially a parallel to our national constitution, obviously, which abolishes slavery, but carves out a provision for unpaid labor if you are a prisoner. I believe you also reported that this measure failed in the past. What's different this year, and if you could even say what happened maybe in 2016 as well?
Sure. So in 2016, this question failed, and apparently there was some confusion on what the ballot was actually asking, which may have contributed to why it failed in 2016. And this year, it seems that they made an attempt to clarify the language, so that may help.
Yeah, that's certainly an interesting measure there. So we'll follow up with you on that as well as the other measures you covered, Jaclyn, here. I think there's others about gender identity discrimination as well, and as I said, minimum wages. So thanks for joining us, Jaclyn.
Sure, thank you.
Sticking with the election-related news in our second item today, we'll have an interview with former SEIU head Andy Stern in the column. SEIU is obviously one of the biggest unions in the country. To sum up sort of the gist of what Stern relayed to us, was essentially his view that a lot of union leaders shouldn't serve as DNC officials or as party spokespeople at the Democratic National Committee. And this is interesting, of course, in the background of these elections as we're seeing sort of factions develop in the two parties, right? On the Republican side, you've got sort of the Trump faction, and you've got sort of the more mainstream Republican faction led by Mitch McDonald and folks like that. On the Democrat side, you've got folks like Nancy Pelosi and Chuck Schumer that sort of represent the old guard of that party, and sort of more progressive candidates, obviously like Bernie, and we're seeing newer ones crop up like Stacey Abrams and Andrew Gillum. So this will be interesting to see how this plays out, and that's exactly what Stern is speaking to here, how the union movement, which tends to support Democrats, will sort of respond to these developing factions within the Democratic Party. And we have a bit more on it in the column. Our last item today takes us to a big labor case involving McDonald's in 5 through 15. This case is sort of developing into an odd battle within the case between McDonald's attorneys and some outside folks who are not directly involved in the case. These are two ethics officials from both past administrations' White Houses, the Obama administration's ethics czar as well as the Bush administration's ethics czar. And the Bush official, Richard Painter is his name, weighed in the case between McDonald's and 5 for 15 over whether McDonald's should share liability for workers in its franchise locations. McDonald's obviously is a large corporation, but McDonald's does not control the workers directly in each of its franchise, the store locations you see on the street corner, obviously. And so Painter weighed in on the case to give his opinion that in reading the ethics statutes, two members of the labor board should have to sit out this case because they have a conflict of interest. McDonald's attorney kind of lobbied back with a very strongly worded opinion where he sort of pointed out that Painter has a political career, who ran for Senate seat, was very anti-Trump during that race. Painter then responded again by saying these are ad hominem attacks. They're relevant to his arguments about ethics. And the latest development now is that Goldsmith, I should have said Painter actually requested that the board order Goldsmith to strike his motion, or at least those portions that he said were offensive. And Goldsmith has now responded saying we stand by our arguments, and under the board's rules, it's perfectly legitimate to point out when someone might have other motivations for weighing in on a case. So we'll definitely keep following that interesting odd sort of fight there and keep you up on it. All right, that's it for this week, folks. Thanks for punching in with us for the Labor Desk's Monday Morning Musings. For more coverage, be sure to check out our website where the Punching In column is hosted. That's news.bloomberglaw.com. And of course, you can always follow me on Twitter at Hassan Kanu. See you next week.